Welcome to Big Deal. Now, Competition Commission of India has changed the way India does deals. And the recent amendments that have been proposed, yet to be notified, are set to bring about some meaningful changes in mergers and acquisitions, as well as the dominance antitrust landscape of India. Let me welcome on the show the Competition Commission Chairperson, Ashok Kumar Gupta, to discuss the changes that are proposed and also its impact. Welcome to CNBC TV 18, Mr. Gupta. And to begin with, now this has been a big talking point. As an overarching theme of the changes made, how do you see the changes that have been proposed, which expands the scope of investigation for the Competition Commission of India? And also, corporate India, Mr. Gupta, is worried about the seizure as well as the raids powers that have been vested in the DG.
See, first of all, let me thank you, Nisha, for inviting me to the show. Good afternoon, everyone. Well, let me point out that the search and seizure powers were already available with the Director General. In the existing statutory architecture also, the Director General has been vested with the search and seizure powers, which is deriving from Companies Act. The bill now proposes to make that provision of the Competition Act as self-contained without reference to the Companies Act. I see no reason for any worry on this account. Let me also point out that search and seizure operations would be carried out only with the authorization of the Chief Metropolitan Magistrate, as is provided even now.
All right. So that's a fair amount of clarity, and thanks for allaying those fears. But I'm sure the guidelines that come out once the passage of the bill is done would be clearly stating where corporate India lies and what are the powers that are vested in the DG. Now, one very significant proposal that I now want to come to in the bill is for the reduction of the overall time. Now, this has been the big ask. Limit for approval of M&As from 210 days with the stop clock to 150 days. In fact, the amendment also obligates CCI to form the prima facie opinion within the 20 days period of the receipt of the notice. So all these are positives. Now, can post-amendment the industry expect a faster clearance now with these changes on the deals? And is CCI geared up? My bigger question to you, Mr. Gupta, is does CCI have the manpower capacity to take up this challenge of faster approvals?
Okay, I think this is a very important question. First of all, let me explain the rationale of M&A's regulations.
Yes.
M&As bring business synergies and are vital for achieving efficiency by scaling up operations. It can also enable companies to have global footprints. So it has always been the endeavor of CCI to give quick approval so as to facilitate inorganic growth of businesses. Nevertheless, experience across the globe shows that some mergers may change market structures and distort level playing field. This may, over a period of time, result in unfair pricing and poor quality of goods and services. This may require correction at the stage of merger itself. The introduction of Green Channel for automatic approval of combinations in August 19 has further cemented the trust-based system of CCI. It is the first of its kind system in the world wherein the transactions get automatically approved at the time of filing. Today, nearly 30% of the filings are under Green Channel, which demonstrates the success of the initiative. CCI has always facilitated quick approval of M&As.
Right.
The average number of days to approve M&As has already come down to 17 working days only, primarily because we trust the information filed by parties. Since the timelines have been compressed, we will continue this trust-based regime with an underlying assumption that parties would reciprocate by providing full and true disclosures in a timely manner. At the same time, making of false statement or suppressing information will now attract aggravated penalties as proposed in the bill, apart from other consequences.
Yes. So I'm glad you mentioned penalties, and we'll come to that in a bit once you have clarified the several changes. But Mr. Gupta, I must say that I've spoken to several experts working on with CCI closely, and they said that these kind of timelines may lead to more invalidation of the filings and lead to refilings, or else may also lead to lapse into approvals. So that is the viewpoint that I'm getting, but we'll have to see how it really manifests. Now, another important aspect, which also expands the gamut of CCI's approach and scope, is the bill proposing the introduction of deal value threshold, Mr. Gupta, of 2,000 crore rupees, which is very small. As an additional criteria, you've put this for notifying the M&As to CCI for approval, and if the target has significant business operations in India. Now, what was the gap under the extant regime of thresholds under asset turnover, which you think this one is seeking to fill? Now, this expanded scope of deal value. And is it also aimed at the tech digital sector, especially the killer acquisitions that we are seeing? US has spoken a lot about it in the antitrust regime. And this big tech killer acquisition, is it specifically for that? And how will this really work?
Nisha, let me at the outset clarify that the division is sector agnostic and
Right.
not specifically directed at acquisitions taking place in digital ecosystem. However, in new age markets, factors such as users, data, growth, and network effect have become means of gaining significant market position. It means valuation is dependent on these factors and not on assets or turnover. Therefore, entities operating a successful business model in new age economy command significant valuation with insignificant assets and turnover. Presently, jurisdiction of CCI is limited to M&A transactions that meet the asset turnover threshold specified in the law. So some transactions which may cause competition concern may not get captured in the existing framework. Thus, a regulatory gap was observed in the regime, which necessitated introduction of an additional notification criteria such as deal value. Germany and Austria, through legislative changes, have introduced new transaction value thresholds into their merger control regimes. US already had it.
That's right. So killer acquisition has been a big talking point there as well, and we'll wait to see that. But Mr. Gupta, what about the local nexus? How do you define local nexus? There is a lot of ambiguity regarding that. If you can give some clarity on that.
See, this is the crux of this particular provision, and we have to define it very, very carefully. Not all deals valuing 2,000 crores or more need to be notified to the CCI. I think impression is that all the deals will have notified. No, all deals need not be notified which are about 2,000 crores. Hence the importance of local nexus criteria. I'll compare it with something like de minimis. It is meant to exclude M&A transactions where the target exclusively operates abroad or has limited business operations in India. Since in new age markets, assets and turnover do not reflect correct market valuation of the target, which is dependent on the possession of intangibles such as data, network effect, users, source of supply, etc. Local nexus criteria for the purpose of the deal value threshold should also be based on factors that affect valuation of an entity in new age markets. These criteria would largely be based on market-facing factors such as number of users, number of contracts, aggregate amount of payment received, etc. And we have to work out regulations to define these parameters. Local nexus criteria would be provided through regulations framed by CCI. This is important as CCI will have to dynamically respond to changing market conditions. Why I am saying they should be defined by regulations, because we have also to be dynamically responding to the changing market conditions. It cannot be frozen in time. We are
Right.
aware of what this criteria is. Therefore, CCI will deliberate on the issue in great detail, and only after wide-ranging public consultations with stakeholders, such regulations will be formed up. We will provide certainty and predictability to stakeholders. So I think this should allay the concern of the industry.
Right. So two important aspects that came out in the clarity given by you, Mr. Gupta. One of them is that not all deals with the threshold of 2,000 crores deal value will come under the gamut. You will come up with regulations on this particular front. And on the other hand, there will be technicalities which the experts will work on in terms of the criteria. So that's a fair bit of understanding coming out of what you said. Now, another aspect which is coming in as a very big relief for the industry in M&A is going to be the open market purchases. Now, time sensitive. Just now we saw one particular largest cement deal that is getting consummated right now. That was stuck for first CCI approval, then the open offer will take place, and the time sensitivity and the stock market volatility can impact the price dynamics. Now, had these changes come in earlier, it would have probably, allayed some of those concerns. So this is a very welcome change. But how will it work? Because if CCI approval wants material changes in remedy or does not approve or is after a very long period of time, how will this work? Because open market purchase has taken place even before CCI has approved it.
See, I think this was a gap which now this bill is to plug. Presently, parties to M&As are required to notify CCI and wait for its approval for 210 days before consummating the transaction, whichever is earlier. In case of market purchases, now this is a different cup of tea altogether. In case of market purchases where prices are volatile, if a person is required to wait for approval of CCI, it may lose the opportunity to buy the shares at best prices. Further, if any information relating to an acquisition of shares of a listed company is made public, it may result into speculation in prices, and such a proposed acquisition may become unprofitable or unviable and thus may fail. Therefore, time taken for their competition assessment and approval may increase the cost of transactions. I think this is what we don't want. To address the above eventualities and in line with the international best practices, the proposed amendments seek to establish a special framework for market purchases. Under this framework, parties can conduct market purchases without prior notification and approval of CCI. However, I think this is very important. However, subsequently, they would be required to notify CCI within the specified time and shall not exercise. I think we can concentrate on this. Shall not exercise any ownership or beneficial rights or interest in such shares till its approval. So, standstill obligation to that extent still remains intact.
Yes.
Thus, the proposed reform balances the need of standstill requirement and compelling element of time sensitivity, as you mentioned, in market purchases. It's a major step towards ease of doing business.
Yes.
I see no reason for any regulatory uncertainty due to this reform. Since the merger control regime coming into operation, CCI has not blocked any transaction and has addressed M&As which were likely to cause appreciable adverse effect on competition through behavioral and structural remedies. Of course, in a given situation. Now, again, of course, in a given situation where the deal is likely to distort market, decisions will be taken accordingly.
Yes. So
course,
that question will still remain, but one big clarity you gave is that you cannot benefit from that transaction, nor is there an ownership. Yes. So my guess is an escrow account kind of a situation.
Something of that sort. Yes, something of that sort will be created where you can put those shares and all, and once approval is given, then you can have the beneficial rights over them.
Now, Mr. Gupta, we were discussing several aspects. Now, the bill also proposes a lower threshold of control. Now, control is a very big aspect, and Many different regulators and laws have a different definition of that. How will this particular change in control definition really affect merger control regime in India? And what is the definition of material influence now that you have said? It's a very broad term, and the industry finds it difficult to really understand the scope of it. If you can help us understand with the examples.
See, presently, control includes controlling the affairs or management. Now, the bill proposes to define control as meaning the ability to exercise material influence in any manner whatsoever over the management or affairs or strategic commercial decisions. Competition is a highly dynamic activity, and therefore competition law, if it is to fulfill its mandate, has to be equally dynamic. The relationship between the shareholders and investors and enterprises is also fast evolving, and the concept of control, therefore, needs to be one which enables the assessment of such relationship in the proper perspective. Accordingly, it is felt that the concept of control needs to be linked with the ability to influence the strategic commercial decisions, which actually causes the change in market dynamics.
Right. So while you are saying that, Mr. Gupta, one industry concern has always been that, the board composition is done to put those checks and balances on material influence of one particular director. So that is one point of view really coming in. But I'll move on to the other one. The bill proposes to broaden also the scope of anti-competitive agreements and also seeks to include the parties facilitating the anti-competitive horizontal agreements. Now, this expands the ambit of your investigation, and the proposal is targeted at hub and spoke cartels. How will the facilitators be treated in this context, Mr. Gupta?
Let me explain that there is no change as such in the decision practices of the Commission. We have been interpreting control to mean material control only, ability to exercise material control. So the proposed definition of control in the amendment bill is on the same lines as the CCI's decision practice, and thus does not change the practical parameters being followed. We are not going to change anything. Probably we might be providing more clarity now, and we might be formalizing this interpretation of control. It is expected that the change will make shareholders more aware of their statutory obligations and prevent any unintended non-compliance.
Yes.
The assessment of material control requires a case-by-case analysis of the overall relationship between the acquirer and the target. In making its assessment, we will have regard to all the circumstances of the case. Material influence may arise through factors such as representation on the board of the target, contractually agreed consultation rights, veto rights, voting percentage held by the acquirer. Let me assure the industry that there will not be any change in the decision practice of the Commission, and we are not lowering the threshold in that way.
All right. So that's a big comfort coming in, that you're not lowering the threshold and it is only defining it. There's no change in your strategy when it comes to control. But what about hub and spoke cartels and the decision to also expand it to the facilitators? Now, that's a very large gamut to really investigate. Can you give us some examples also how it will work?
See, I will again say there was some gap in our competition law. I will explain the situation. The law presently provides that certain horizontal agreements, including cartels, are presumed to have an appreciable adverse effect on competition unless otherwise rebutted. There exist certain unique forms of agreements in which a third party, that is a hub, organizes or facilitates collusion between two or more competitors, that is a spokes. So one entity acts as a hub and there are spokes. In such cartels, the hub communicates with one or more spokes and causes the sharing of information between the spokes. Spokes on their own are not in touch. So that is not cartel among the spokes in real sense. It is through the hub that everything is being done.
Right.
When spokes are captured within the presumptive rule of appreciable adverse effect on competition, the hub not being in horizontal level with spokes
Yes.
was outside the scope of this presumption. In this backdrop, the bill proposes to expand the scope of cartels to include hub and spoke arrangements implemented by entities involved at different levels of the value chain within the presumptive rule. The bill allows CCI to proceed against any entity which acts as in facilitating a horizontal agreement or cartel in whatever capacity.
Right.
At present, we are not able to capture certain facilitators of this horizontal cartel. I
Right.
think this will enable us to uh, catch those facilitators also.
Right. So the entire ecosystem. But I will skip to the last question. I had many more, but I want to ask you one overarching question. Do the changes, equip CCI to have better control and regulation over the digital market, which is so dynamic and evolving, Mr. Gupta? Very quickly, we are running out of time.
See, I think our existing dispensation is robust enough to deal with the digital markets. We have been dealing with a number of cases of the digital ecosystem, but now we have got a number of provisions in the existing bill which will further enable us to do this job more efficiently and effectively.
Right. All right, Mr. Gupta, thanks so much for patiently explaining several of those aspects, but this will be open to many discussions, debates after it has been approved by Parliament. And then probably your guidelines will fine tune how it really works. But thanks so much for the initial clarity, and we'll wait for the passage of this bill. So those were some important takeaways coming in from the CCI chairperson on the amendments that are proposed to the competition law.